Slaying Sunnah, Abu Ishaq al-Shāṭibī's concept of Bida in Al-Iʻtiṣām, McGill University, 1999, A.S. Jahar, Montreal, Canada. Chapter 3. Istihsan, juristic preference in Maliki doctrine, according to Shatibi, is equivalent to maslaha mursala, which is public interest. Such istihsan, therefore, is not alien to stipulated indicants. That means stipulated evidences, adillah. In such a statement, Shatibi may have been trying to stress that istihsan itself is different from arbitrary, rational judgment in instances where textual evidence is lacking, and therefore it is not to be counted as innovation. For according to Shatibi's understanding, legal cases should primarily be in line with the ends of the law, maqasid al-Shar'iyya, rather than with pure reason. The ends of the law were necessary as a key element, and they depend upon divine wisdom, hikmah, a solid basis on which to draw when there is a lack of conformity between qiyas, ratio legis on the one hand, and istihsan on the other. Here the footnotes are important, so I will give them to you. Sarkhasi, in his Usul, page 204, quotes the prophetic saying, "Whatever the Muslims deem as good is goods with God," and Halak mentions this in his History of Islamic Law, page 107. Halak notes that the argument of istihsan in the beaks of predatory birds, analogizing with the revealed stipulation that the use of bones of dead animals is lawful. Istihsan is as a tool to deem something good or bad is employed by Hanafis and Malikis. Both schools use particularization of universal by either dalil, indicant, textual or contextual. Malikis then espouse istihsan by saying that maslaha mursala, public interest, be invoked, while Hanafis take istihsan by a solitary report, khabar ahad, and that was mentioned by Shatibi in his Muwafaqat, volume 4, page 150. As the difference between worship and mundane matters is a fundamental point in Shatibi's view, the function of istihsan in these two domains has to be treated separately. As we have seen, worship is considered perfect in Islamic law, as well as impossible to justify on the sole basis of reason. Mundane matters, however, are not only rationally understandable, but may also change in accordance with time, place, and condition. Shatibi therefore tolerates the use of istihsan in mundane matters, insofar as the dalil neither stipulates nor contradicts the Shar'iyya. Employing istihsan in the Shar'iyya without any dalil is categorized as bid'ah. For Shatibi says, not every istihsan is true. The cases of istihsan which Shatibi rejected appear to have been efforts at using pure reason to judge actions as good or bad without a dalil. On the contrary, if istihsan is ruled as conforming to a certain dalil, it is lawful. Ibn Arabi, as quoted by Shatibi, defines istihsan as setting aside a certain dalil temporarily on the condition that hardship is present, or as an exceptional solution when the laws applying to a certain case are ambiguous. On the one hand, applying a particular legal law can lead to difficulty, while on the other, the reduction of hardship is of prime importance. For these reasons, istihsan can be applied as law in the following instances. First, in matters of urf, local custom. Second, in maslaha, public benefit. Third, in the order to ease human burdens. And fourth, to eliminate hardship. Ibn Rushd, moreover, categorizes istihsan as abandoning qiyas, where reliance solely on the latter may lead to transgression of the law. Having elaborated the issue of istihsan as it is treated by these two Andalusian-born scholars, Shatibi concludes that istihsan is in conformity with the universal indicants of the Shar'iyya, insofar as no clear dalil from the Quran or Sunna is expressed. Indicants function to bring clarity to words which have a plethora of meanings, such as when the meaning of the Quran is specified by the Sunnah. Shatibi agrees that reason can be employed to interpret the Shar'iyya when used in conjunction with istihsan. He, however, rejected the use of istihsan where rational judgment is allowed to dominate the Shar'iyya. This is because the companions, he insists, only employed reason if there was no clear indicant from the Nas, and only by referring it to the understanding of the roots of the Shar'iyya. There never came the point of saying, quote, "I decided this because my mind tended towards this conclusion." The subjectivity of pure istihsan, as Shatibi states, lies in the fact that the decisions as to what is good or bad in the human mind may change depending on purposes and conditions. This was evidenced by the people of innovation who rejected the search for the truth of the Shari'iyah. They resented the people of science, Ahl al-Ilm, because of the latter's consistency in applying the Shari'iyah. Stay tuned for many more parts.